Hi, everyone. Thank you for dialing in and for making time for this webinar. This is actually the second webinar in a two-part series on climate scenarios. The first one was called Putting Climate Scenarios into Action. It was held on February 13th, and the recording is available on our C2ES YouTube page. For today's webinar, part two, we had around 229 people register, so we know there's a lot of continuing interest in climate scenarios. And before we dive into the content of today's webinar, let's take care of a few housekeeping items. This webinar is being recorded and it will be posted on our C2ES YouTube page. And because we have so many participants, we will go ahead and use the GoToWebinar question box for questions. So feel free to type in your questions online. I'll hold them until the end and then I'll raise them for our panelists during the moderated discussion. So I wanted to go over the agenda really quickly. I'm going to start us off by providing an overview of what C2ES is, and I'll review our work in this area on climate reporting. Then I'll introduce the panelists. Maggie Peloso will walk us through the current legal framework and trends in voluntary disclosure. Prell will help us understand the outlook for new policy and investor activism. And then after that, I'll lead our discussion session by asking the panelists a few questions. After that, we'll take audience questions. So with that, let me begin by saying a few words about C2ES. So we are an independent, nonpartisan, nonprofit think tank focused on climate change. And our core mission is to find practical solutions to reduce greenhouse gas emissions, expand clean energy, and boost resilience to climate impacts. One of our unique features is that we have a Business Environmental Leadership Council. And as you can see on the slide here, it includes top companies from many sectors, including electric power, manufacturing, transportation, IT, oil and gas, and finance. It's actually one of the largest US-based groups of companies devoted solely to addressing climate change. And one of the benefits of this council is that it's multi-sectoral. So unlike a trade association, companies can talk to their partners in other sectors about climate policy. What I have here on the screen right now is a screenshot of our new website. I encourage you to check it out, c2es.org. All of our publications are posted on our website and they are free to the public. And right now what you have on your screen is a screenshot of our most recent publication on the topic we're discussing today. It's called Beyond the Horizon, Corporate Reporting on Climate Change. And if you look at your control panel for GoToWebinar, you should see it attached as a handout. It's also available for free again on our c2es.org brand new website. And in the report, we explain what we saw as the key opportunities from increased climate reporting. And I have them here on the slide for you. We think that companies might find that there's increased internal understanding and communication about climate-related issues. We think that companies might be better positioned to take advantage of opportunities and prepare for risks. We think that this is a way that would help companies proactively address stakeholder and investor concerns about climate change, which may help reduce costs for companies related to information requests and shareholder proposals. And we think that it might help investors identify opportunities to invest in companies focused on climate solutions. At the same time, we found in our research that there are a number of challenges related to climate reporting, and we group these in 8 categories. The first is uncertainty about climate change impacts and the speed of the transition to a lower carbon energy supply. The second is a lack of clarity on the timeframes to consider. And third, which is relevant to today's discussion, is that there are legal issues related to determining materiality, and there's a perception that financial disclosure of climate risks would not be of interest to average investors. There's also ambiguity on the appropriate level of detail. There are some more challenges that we talk about in the report, which include differences in the quality and precision of financial and sustainability data. There are often internal coordination challenges, And in general, there are costs and complexity, associated with completing the analysis. The final bullet I have on the slide here is that there's a difference in perception between data users and data preparers on the usefulness of scenario analysis and the financial disclosure of metrics and targets. So in light of these opportunities and challenges, we came away with 4 key findings. Number one, we did feel that the Task Force on Climate-Related Financial Disclosures, their recommendations did strike a good balance between the need for greater transparency for stakeholders and investors and the need for companies to have flexibility in how they report on these issues. And we believe that even in the absence of action by U.S. regulators, companies are likely to expand and enhance their climate-related disclosures. And as I mentioned earlier, there are several benefits from greater transparency. At the same time, we believe that more work is needed to help companies implement the recommendations, particularly around scenario analysis. And this last bullet is why we organized this 2-part series on climate scenarios, and that's what we want to focus on today. So with that, let me introduce our panelists, and we can jump right in. Cameron Prell is a partner with the Coefficient Group, where he advises and represents private sector clients and governments on a number of issues related to energy and environmental markets and financial transactions. And Maggie Peloso is a partner with Vinson and Elkins. Her areas of practice include environmental law and climate change. She advises clients on a variety of issues, including on climate change risk management. So we're very fortunate to have both of them here with us. And with that, let me hand it over to Maggie.
Thank you, Fatima. So I wanted to begin today by talking a little bit about a couple of the issues that Fatima raised in the introduction slides, the first being materiality, and the second, the comment on the absence of action by U.S. regulators. I think the big takeaway from these first couple of slides is that there is not a particularly prescriptive framework within the United States regarding the disclosure of climate change risks. And so what that means is that one of the things that we are already seeing and we will continue to see over the coming years is a continuing dialogue between companies and their investors about what level of climate disclosure is material and appropriate at any given time. Just to foreshadow a little bit, a lot of that is going on through the shareholder proposal process, which I will dive into in a bit more detail later on in these slides. So the first thing is this issue of materiality. The SEC defines material information as information that there is a substantial likelihood a reasonable investor would consider important. So essentially, when you're putting together your securities filings, you have to think about, would the average person who's investing in my company choose to invest or not invest or change the way they're investing in my company if they knew this information? And that's the threshold. The SEC has specified some potential trigger areas for materiality of climate issues in particular. These come from the 2010 SEC guidance on disclosure of climate risks. So this is guidance, it's not required, but they flag legislation, regulation, international agreements, indirect consequences of regulation on a business. So that would be things like the people to whom I sell my product are being regulated in a way where they might not want as much of my product. And then finally, physical impacts. So if there are physical impacts of climate change, like sea level rise, increased storminess that might disrupt a company's business, those are potentially material issues. The biggest thing to note here is that materiality is really, in the eyes of the management, that becomes a decision at the company level about whether those risks rise to a level of significance that they need to be included in securities filings. It's been really interesting over the last 5 to 10 years, as there has been an uptick in voluntary climate reporting. A number of groups, Ceres has really been at the forefront of this, to point out the differences between what companies choose to put into their voluntary climate disclosures, so to places like CDP, other types of voluntary shareholder reports, as compared to what goes into the 10K. And historically, a lot of that reporting on the securities filings versus the voluntary reports has really sort of said, well, gee, isn't that interesting? Companies acknowledge all these risks, but they clearly don't think they rise to the level of materiality because they're not getting into their securities filings. And one of the things that we're seeing now is perhaps some more robustness in the statements of groups like TCFD, the Task Force on Climate-Related Financial Disclosures, and CDP and others, and shareholders and businesses suggesting that they do in fact consider some of those risks to be material. The one other thing I do want to mention here, Fatima also asked me to address state laws a little bit. There's really not much of a state regulatory framework that governs materiality or climate disclosure, but I would be remiss to not mention the Martin Act, which is the New York Blue Sky Law. It gives the New York Attorney General the power to investigate and pursue enforcement to stop securities fraud, and it applies to all companies that are traded on the New York Stock Exchange. So that applies to both public statements that companies are making and to their securities filings, and this is the statute that underlies the current New York Attorney General investigation into ExxonMobil's use of carbon pricing and statements it made about its reserves in the past. Fatima, can I have my next slide, please? So as we think about what companies consider material and how they are going about disclosing risks, one of the big questions that we get as we advise clients is, what are my peers doing? Is everyone else putting this in their 10K? Because if so, maybe I should too. And so I think when you start to think about scenario analysis, one of the things that really becomes a question in terms of mass adoption is, when will we reach a tipping point? When will we get to the point where so many companies start to engage in scenario analysis and either include it in some kind of a voluntary climate report that the company's putting out or in their 10K? And so it's a thing where it's like a snowball rolling downhill. So over time, as some companies start to adopt, that will increase pressure on others. And that would likely change the calculus on whether these kinds of risks are material to include in a 10K. Right now, we're really not at that place, and we see a lot of resistance from the further incorporation of scenario analysis, particularly into required securities filings. One thing I did want to note is there is sort of one big report out there that's against TCFD in some ways, I would say, and it's this report from IHS Markit, which does a lot to note that the kinds of disclosures that TCFD seeks are a pretty significant departure from established concepts of materiality. I don't know that that's something that will control what happens in the future, but I think it's an interesting thing to note that we're sort of at a turning point. And I think here the other real question is, how long can the U.S. and Europe remain divided? I think Cameron will talk more about international regimes, but expectations for disclosure are a bit different and a bit more robust on climate in Europe than they are in the United States. And part of that is, candidly, because of the different levels of development of the climate change regulatory regimes. But it does create some tension for companies that operate across borders. Okay, next slide, please. So I'm going to spend a bit of time talking about shareholder proposals submitted under the 14A8 process. So this is a process where shareholders in a company can submit proposals that a company then has to place on its proxy ballot for the annual meeting. To qualify to submit a shareholder proposal, a shareholder has to hold at least $2,000 of stock in the company and have held it for at least the prior year. So those are minimal threshold requirements that lots of potential investors can meet. In the ESG space, most of the proposals that we see brought are actually brought by smaller shareholders. But the reason that they're important, as you'll see in this next series of slides, is that we're seeing an increasing number of proposals on environmental sustainability and governance, so ESG matters more broadly, and on climate change in particular. And in 2017, we had a watershed year where institutional investors started to support those proposals. And that has really changed the dialogue around where and how companies might engage with scenario analysis and make their climate disclosures more robust. Next slide. So this is a breakdown of some of the types of proposals that we saw in 2017 that is really just meant to show that climate change reporting or structures tying executive compensation to climate change, or seeking board members who knew something about climate change or environment more generally, were really active areas for shareholder proposals last year, and that's something that we do think will continue into the future. Next slide, please. So this is a closer look at trends in environmental shareholder proposals in the Fortune 250 over approximately the last 10 years. There are just a couple of things that I want to note on this slide. The first is, as you can see, generally the number of proposals is increasing. The second thing to note is that the percentage of votes for these proposals has gone up quite significantly. So, in 2008, 2009, 2010, the levels of support for these proposals were really low, and that has really changed dramatically. I do think that is in large part because the proposals themselves have grown much more sophisticated. So in the early days of climate shareholder activism, the kinds of proposals we saw were things like, we want you to do a report about climate change, and it would be that general. And so it was very easy for corporate boards to say, we're thinking about climate change, and writing a generic report like this isn't going to help us and isn't going to change anything. And what we saw starting in 2017 were much more sophisticated proposals making very particular requests around disclosure of climate information, and particularly scenario analysis. Fatima, can I have my next slide? So this is the text of what I would call the generic 2 degrees Celsius proposal. This is the proposal that many energy companies saw last year, both upstream, so oil and gas producing companies, as well as utilities. And I've highlighted here the language that is particularly important with respect to today's discussion about scenario analysis. So this proposal actually specifically asks for scenario analysis. And if you look at the final sentence here, it says, reporting should assess resilience of the full portfolio of reserves through 2040. And it's looking for a range of potential scenarios. And so this is the request that was most frequently submitted in 2017 and has been voted upon. And on the next slide, we should be able to see the voting results. Or, I'm sorry, one slide ahead of myself. So on the slide after this, you will see the results of the voting. And the thing that I think is important to note before we get there is these are some of the leading global asset managers. So these guys hold large shares in a lot of these energy companies. So the way they vote can swing outcomes. And one of the things that we saw in 2017 that was really different from prior years is that these folks started to vote for climate and other environmental shareholder proposals. And now the next slide actually does have the results from last year. So this is just a table showing the 2017 proxy season 2 degree Celsius proposals that were submitted at energy companies. And the way that this is coded, the ones that are in green, those are proposals that received a majority vote in favor from the shareholders. So that means that the shareholders won or the company lost the proposal. There are two things I want to point out about this slide. The first is, if you notice, there are quite a few companies on here who didn't lose. A loss is greater than 50%, but who had votes in the high 40s. So we're in an area where, were they to receive this proposal again, they would be at risk of losing it, and they might want to be thinking quite seriously about how to address the investor demand for climate shareholder analysis, or scenario analysis, I apologize. The second thing to note is that these votes are on what are called precatory proposals, which means they are advisory in nature. So a loss of this proposal does not actually obligate the company to do anything. However, companies who choose to not act on these shareholder recommendations can face a variety of potential ramifications in the future. So you may see that an investor is unhappy that a company did not respond by providing the additional climate disclosure that was requested, and they might in the following year come back and say, you know what, we're just not going to vote in favor of your preferred directors who are going to sit on your environmental health and safety committee, or we want our own directors who know something about climate change. And then, of course, the other risk that underlies all of this is that we've seen a big rise in socially responsible and environmentally responsible funds. So the reason that groups like State Street, like BlackRock, like Vanguard are voting for these proposals is because they're getting pressure from their own clients, the individual investors, to create funds that have companies in the portfolio that are climate aware or socially responsible or environmentally responsible. And so at the end of the day, companies choosing not to respond to these requests or not disclose this information face a business risk of essentially capital flight, of money flowing elsewhere to companies that are saying more, doing more in terms of climate disclosure and climate risk management. Next slide, please. So this slide is just to re-emphasize the importance of the shift in voting behaviors by some of the major asset managers. And so this is just showing the percentage of for votes for each of these companies in the July 2016 to June 2017 period. Can I have the next slide? So I think when you get down to the real legal questions behind this, you get to what does this all mean? You might lose a shareholder proposal, you might be close to losing a shareholder proposal, you have some sort of external investor demand for disclosure. That doesn't necessarily mean that companies are going to run out and do scenario analysis and disclose it right away. There are a lot of broad and interlocking dimensions to think about as companies start to think about disclosing climate risks. Oftentimes, as companies begin to think about things like climate scenario analysis or any kind of enhanced climate disclosure, what we tend to see is that they're doing it in a voluntary context. And that's actually exactly what we've seen so far in the response to the lost 2C proposals last year. Each of the companies that lost issued an investor report engaging in scenario analysis. So that's a voluntary, not a required disclosure. When there is an increasing gap between what companies are disclosing voluntarily and what is in their securities filings, that can create an opportunity for investors or others to come in and ask questions about why it is that companies don't think that those risks are material and perhaps push for their inclusion in securities filings. And there's also lots of other considerations. So for example, a number of the companies that have faced pressure to engage in scenario analysis and enhance their disclosure in the securities context for climate risk are also facing lawsuits over a variety of climate tort issues. And so it's important for those companies to think very carefully about how those things interact as they go forward. Next slide, please. And these are just some of the risks that can happen if a company isn't really coordinated and thinking about how they are going about responding to a shareholder demand or just, general trends in the market towards increased climate disclosure. One of the big things to touch on here is benchmarking. This is something where we've really seen some big trends in the last couple of years. So within the last year or two, CDP has gone from just collecting everybody's voluntary climate disclosure information to engaging in some pretty aggressive benchmarking. And that is the kind of thing that leads many companies to start to think about, well, do I want to disclose and be in the bottom quartile for my peer group, or do I want to just get an F for not reporting? And I think the rise of benchmarking, it's on the upswing. So this year, ISS Institutional Shareholder Services, which is one of the groups that helps companies figure out how to vote on shareholder proposals, has released its own ESG scorecard. On the climate dimensions, we're seeing a lot of the kinds of questions you see on CDP repeated there. I think the other thing to really emphasize here, it goes back to one of the issues that Fatima raised at the beginning around data quality. There are significant gaps between the quality of financial data and the rules around the robustness of financial data that are reported in securities filings and the kinds of sustainability data that companies may have at their fingertips as they start to think about doing something like a climate scenario analysis. And so I think it raises real questions about what is possible and how good is that data and whether a company wants to be putting that information out there and facing the risk that they will then be pushed to include it in something like a securities filing where the quality of the data is quite important. Next slide, please. I wanted to touch just a little bit on the TCFD and its view of how the recommendations around implementing climate scenario analysis and incorporating it into disclosure would go forward. TCFD is asking companies to look both at transitional risks and physical risks. So transitional risks are the kinds of risks that I think we see more frequently disclosed and addressed, and those are the kinds of things like the Paris Agreement exists, and so global markets might shift away from fossil fuel powered transportation, and therefore I might not be able to sell as much oil or gas in the future, right? So that's I'm in a carbon intensive business, demand for carbon might go down, so there are financial risks to my company. The other important piece of TCFD that I don't think has gotten as much attention as it should is the physical risk. So are there going to be disruptions to your supply chain? Do you have enough water to do what you need to do? Those kinds of issues that are perhaps not quite as far along in their development. TCFD's expectation seems to be that this information will ultimately be included in company financial statements, but they're not saying do a scenario analysis right now and put those results in your scenario analysis. It's more of a pathway towards understanding and assessing and improving disclosure of risk. And there are 4 core elements to that, which are governance, strategy, risk management, and metrics and targets. And I think scenario analysis really plays into strategy and risk management issues. And then can I have my next slide? I just wanted to end by touching briefly on some of the kinds of industry responses that we are seeing to investor requests for scenario analysis. So this slide, these are some poll quotes from Chevron's climate report that was issued last year, but they are fairly representative of the kinds of things that we're seeing from industry more broadly now. As I mentioned earlier, each of the companies that lost the 2C proposal last year has engaged with investors and has now released a report responding to that request for information. Each of these reports relies upon the IEA 450 scenario, so that's the International Energy Agency scenario for what demand for various energy sources is going to look like to achieve the goal of stabilizing atmospheric CO2 concentrations at 450 ppm. For the oil and gas industry, I think this is a particularly interesting scenario because in the IEA baseline scenario, demand for oil and gas remains quite robust through 2040. So as they're looking out over, a 20-plus year time horizon, they can say, look, there's going to be demand for our products. We can continue to produce them. The financial risks to us are pretty minimal. And I think that one of the interesting things about that is the tension between the kinds of time frames that climate scenario analysis and enhanced climate disclosures seem to be envisioning. So a kind of multi-decadal future look into what's going to happen to climate and what's going to happen to climate policy and how that's going to impact your business, as opposed to the kinds of time frames on which financial disclosures normally operate, which are typically in a window of up to 5 years, but that's a pretty long time frame. I think the only other thing to say about these kinds of responses is that the responses we've seen from companies vary quite significantly in whether they state that they're trying to engage with the TCFD framework or not. And they all do very, very little to grapple with the physical impacts of climate change. So to the extent we're seeing scenario analysis right now, we are seeing pricing scenarios. We are not necessarily seeing analysis of different kinds of climate futures and the different physical risks to which assets might be exposed. And with that, I will turn it over to Cameron.
I appreciate that, Maggie. That was fantastic. So next slide, please. Before I launch into the ISB issue, I did want to frame things a bit in terms of the policy and the activism going forward. I am coming at this largely from a corporate activism perspective rather than a shareholder activism. And what do I mean by that? Not to use beat the term to death in terms of the tragedy of the horizons, but that phrase that came out of the UK central bank's effort to discuss the need for greater climate risk disclosure was focused on the ambiguity and the uncertainty that Maggie was just referring to regarding forward-facing assessments and mechanisms and the metrics and targets. However, I want to, for purposes here, want to frame it in terms of the horizon for climate risk disclosure itself. And the importance of understanding that although U.S. law is largely kind of silent on figuring out how to define and clarify materiality in the context of climate risks, and that there are no mandated or prescriptive obligations currently other than the SEC 2010 guidance that provide triggers for companies to determine on their own the materiality. All those being said, the trend line that Maggie put up in 2 slides previously in terms of the TCFD framework and how we get to mainstreaming climate risk disclosure is such that we have myriad approaches to the metrics and targets. We have myriad approaches to the strategy, and we have different ideas as to what should be prescriptive, what should not be prescriptive, and how companies should appreciate and integrate them into their annual filings as well as their voluntary filings. So going forward, I think the critical point to be made is not to just assess what peer companies are doing, not just to assess and appreciate that U.S. law is likely to not change very much in the next 2 years on this, such that it's a binary. Should we move forward? Should we not move forward with enhanced disclosure mechanisms? But to appreciate that the utilization of shareholder proxy suits, as well as the recommendations from third-party standards entities, as well as the international activities, are trending towards a series of clarifications on things like metrics and targets and things like strategy. And that's important because corporates need to appreciate now that they have to think from one perfect perspective. What do we want the end game to be? What do investors need in terms of climate risk information and disclosure? And where are things going to end up? And once they start to address those issues, they can address a internal management structure on risk disclosure itself, such that they can get out ahead and get involved with development and clarification on things like the metrics and targets and the strategies. Otherwise, things will get really out of control in terms of what is necessary, what is viable, what do investors really need, and the like. And the reason I kind of introduced that is largely so companies can appreciate that while the U.S. might not be, the U.S. government, that is, might not be leading the charge on this, there are a lot of activities, and obviously a lot of the companies on this phone call are global. There are a lot of activities going on outside the United States that are going to impact the definitional and the taxonomy of climate risk disclosure. So could you, Fatima, can you go to the next slide, please? Yeah, there you go. So in September of 2017, in addition to the great definitional trigger thresholds that Maggie was outlining for the SEC in terms of what materiality means, I just wanted to start off by discussing that in September 2017, the IASB, the International Accounting Standards Board, released a second practice statement on clarifying making materiality judgments in this context. They're called International Financial Reporting Standards, and so the PS2 really is intending to kind of sync up and align with the TCFD framework. And so the first step is to identify the information that has the potential to be material. The second step is to assess whether information is in fact material. And obviously, the key component of all this that everybody on this phone knows is that climate risk is inherently subjective and entity specific. And so the IASB is trying to address that subjectivity in a way that provides some consistency in terms of determination of materiality going forward. The suggested recommendation from the IFRS is organizing the information within the existing draft financial statements and the consistency of communications, such that the primary users, and this is why it's important to understand who your target audience is in terms of disclosure, is getting what they need. The step forward would be to review the draft financial statements, determine whether the materiality has been identified and considered from a wide range of perspectives in the aggregate. And this is going towards the kind of magnitude of the nature and magnitude of climate risk, and what Maggie was suggesting, the physical risk more specifically, at a time horizon that is consistent with your particular sector, the energy sector or the ag sector, whatever it might be. I think what we're seeing is a cleft of sector-based standards and clarifiers on the metrics and standards point of this. I apologize to the moderator for not knowing, but if we could jump real quickly back to the IHS slide that Maggie had, the radical departure. Right. So the IHS report, and if you haven't read it, I recommend it, is important in that the radical departure is in my opinion a good encapsulation of the TCFD framework. However, only for half of the framework itself. So just to recap real briefly, the TCFDs basically encourage and recommend disclosure in 4 different buckets. First being governance, disclosing the organization's governance around climate-related risks and opportunities. Strategy, disclosure of the actual potential impacts of climate-related risks and opportunities on the organization's business, strategy, and financial planning. Risk management being the 3rd bucket, disclose how the organization identifies, assesses, and manages risks. And then metrics and targets, and the scenarios analysis largely fits into that 4th bucket, but we'll reserve that for the time being. Of the 4 buckets, the SEC existing guidance on materiality and the bespoke nature of determination that is internal for every company really goes to governance and risk management. The IHS, in my opinion, on the radical departure side of things, really is talking more about the strategy aspects and the metrics and targets issues, including scenarios analysis. What's the import of that? Well, as we have seen internationally, the UK's Company Act, Canadians' increased involvement in terms of integration of TCFDs potentially into their national and provincial standards. The French law that was promulgated, I believe, in late 2015, as well as recent high-level expert group from the EU on the recommendations of EU-wide integration of the TCFD framework. Their activities internationally are going to drive the standardization, or at least the sector-based approaches to the 2 buckets that are a radical departure from the current SEC framework, and that's the strategy and the metrics and targets. And so on if we could jump to slide 17, I believe, the 2-degree scenario. Sorry about that. There we go. So here is where the rubber hits the road. So what is a 2-degree scenario? Well, as we saw with the IEA 450 analysis, and there's a dozen others that don't need to be mentioned here, the import is that the industry and peers are agreeing to some form of time horizon that is backed into using the 2 degrees Celsius threshold over time, and this rolls in the science-based targets. This rolls in a lot of the great work that's being done on physical risks, data management, and data calculation that can be ultimately used in financial reporting. However, it's important to note that this is entirely picked out of thin air in terms of what should be the right horizon, and also what should be the right scenario. and corporates that are actually engaged in at the national and subnational level on TCFD integration or climate risk disclosure enhanced disclosure metrics need to appreciate that some sectors will view a 2-degree scenario based on a spectrum of options. Even within scenarios analysis, the data management folks, which I do not profess to be as keen on knowing the details of, they will tell you that there are dozens of 2-degree scenarios, and which one is the right one that a company should use, if at all. Should we employ the 2-degree kind of time horizon, or should it be a different time horizon? All of these activities that corporates are largely now being responding to as part of shareholder proxy recommendations and responses need to be understood that the trend line in terms of integration of the TCFD framework is going in a direction that may or may not align with the time horizon that a particular company or particular sector would view as viable, and or what an investor community would need to review for a particular company's performance. So where does that lead us in terms of decision making? So I would like to recommend, if we could go back down to the last couple slides on the thank you. One more slide. There you go. So one more up. I apologize. So on the materiality guidance, there's internal decision making on materiality, and then there's external guidance on or decision making that needs to be conducted on materiality guidance. As we are seeing that the climate risk analysis, particularly on the physical risk side of things, is entity and asset level specific. The trend lines are such that asset level data is not exactly robust enough for most companies to get to a point where that is being fully integrated into their current voluntary and or compliance disclosure activities. But the forward-looking or forward-facing assessment tools that a company uses, whether they employed a third-party consultant or they have an internal management team that is conducting this activity to then translate into some form of disclosure, the assessments over time has import from a legal perspective, first on what SEC would connote as being contingent liabilities going forward. But it also is important because, like, as we are seeing, the peer-to-peer activity or what is best practice in terms of assessments over time is really trending towards some form of 2-degree scenario that may or may not align with a particular sector's interest. The next one is the performance indicators that the company should be using. And here on the policy side of things, I think it's important to note that there are, again, dozens of activities in terms of the clarification on what the best practice is for key performance indicators. You have the ESMA guidance, you've got ISO standards, you've got several other, you've got the voluntary CDPs and the CDSPs and SASBs of the world that would recommend particular key performance indicators that should be utilized. However, this is where either the sustainability or the climate risk disclosure governance internal needs to align with the enterprise risk level policy folks of any company to understand, all right, what are the key performance indicators that we need to kind of assess and get comfortable with as we're going forward, and is there value in engaging with third-party standards bodies as well as with governments abroad, not just in the United States. And then again, the nature and magnitude of climate risk versus the quantitative thresholds. Currently, we're experiencing quite a bit of shareholder activism in terms of quantitatively measuring a particular company's climate risks within each of the particular buckets. But the more salient point should be on the governance and the strategy side of things in terms of what is the company doing to address risks given the nature and magnitude of the challenges ahead for that particular company. And that could mean everything from deep supply chain management issues to asset level concerns on stranded risks and the like. And then if we can, and I know time is running out, if we can then go next to the next slide, please. So strategic decision making. I think it's important that the companies fully appreciate the high level of activity that is going on amongst the investor community, amongst the voluntary standards bodies, as well as overseas, either directly or indirectly involved with implementation of the Paris Agreement, such that there is a growing connective tissue between what audiences are seeking certain information and what information the investor community needs to have in the context of transparency, as well as measuring the performance of particular companies to address climate risks. And so the next kind of calculus needs that at the C-suite level needs to integrate what is going on, appreciate the trajectory of digestion and integration of the TCFDs, as we're seeing a high level of financial institutions as well as corporates are making commitments to integrate the TCFDs, and then governments are seeking to ratify a lot of those activities. And the question is what are governments going to ratify in the future from a compliance perspective? Are they going to go so far as to become prescriptive as to what the key performance indicators should be, what the metrics and standards should be, the time horizons that a particular company needs to measure and calculate their forward-facing assessments? All of those things need to be decided upon now, such that the inevitability of climate risk disclosure and the mainstreaming of it doesn't go to a place where it is incongruent with a particular sector, or at least a particular sector's capabilities and its tolerance for disclosing certain information in a manner consistent with existing SEC disclosure requirements, existing foreign disclosure requirements, and annual filings going forward. So, if I could leave you with any recommendation on that front from here on out, it would be to connect the dots between policy and government affairs offices of your individual companies with your sustainability folks, and such that you are really connecting the dots between where things are trending in terms of voluntary best practice, as well as the great work on the quantitative side of things that companies are doing, and then where things are going to trend, such that you are reaching out and maybe having your trade groups getting involved in terms of harnessing what a particular sector may or may not want to do in a given region, and what would be best practice for your sector or your sector within your particular geographic jurisdiction, and going from there. And with that, I apologize for going a little bit long, but glad to take any questions.
Thank you, Cameron. That was great. And now we'll go ahead and we'll just jump right into our discussion session. I've seen that we've had some audience questions come in, and we will get to those. But I wanted to ask both Maggie and Cameron, from a legal perspective, what are some of the benefits of conducting climate scenario analysis from a company's perspective? If you're on mute, feel free to hit the mute button.
Yeah, so I think one of the things that we talk with our clients a lot about is the potential to be a leader. I don't know that this is necessarily a legal benefit, but as I touched on earlier, and Cameron touched on it as well, there is a lot of behavior in the disclosure space where people look around to see what their peers are doing. And generally, the advice that we give to our clients is that the arc of climate disclosures is going towards the expectation in the investor community and in many regulatory communities that those disclosures will be more robust over time. And I think that the interesting question for companies grappling with those risks now and really living through it is, what can you do to control that arc, right? So if you're going to have to get to something that looks like a full-fledged scenario analysis, is that something that you want to be doing 2 years, 5 years, 10 years from now? And is there some sort of a first mover advantage for starting to do sort of the scenario analysis light, so the reliance on existing scenarios and thinking about how that pricing impacts your company and getting out ahead of the curve so that you are participating in sort of setting the field that others are then going to play on.
Thank you. Yeah, and do you want to add to that?
Yeah, no, I would fully support everything that Maggie just said with the what I was referring to in terms of things like the metrics and targets. If a particular company is comfortable with conducting scenario analysis and is comfortable with the implications going forward of scenario analysis being integrated into some form of climate risk disclosure regime from a compliance perspective, I think that it's exactly as Maggie puts it. Like, you need to get out ahead of that arc, and such that the best practices that you're comfortable with become the best practices on the mainstream basis.
Thank you. And so we talked a little bit about how companies are reporting a lot of this information in different places. So I just wanted to get your thoughts on how companies can promote consistency in their analysis of climate change across these voluntary reporting questionnaires, the investor reports, and the financial filings.
So one of the things that we are seeing is increasing attention to these issues at a very high level within companies. So for example, at the general counsel level and improved coordination. I would suggest to you, Fatima, that this question is perhaps even a bit too narrow, that lots of companies that have really complicated climate change disclosure questions may also have the potential for significant exposure in various types of climate change litigation. And to really get the level of coordination that's needed for good climate risk management, you likely need to have, as Cameron suggested, your investor relations person, your internal EHS people, your internal counsel, both on the corporate and on the litigation side, working together on those kinds of things. You know, it used to be the case, and this doesn't seem to happen so much anymore, where things like CDP that were voluntary were being done by EHS departments with very little oversight from legal or from the board. And it seems that those things are beginning to centralize over time. And I think that continuing to work on centralized coordination to make sure that companies are really speaking in the same voice across those platforms, even if they're not disclosing the same risks because they've made considered judgments about what is material in their eyes and what is not, is really important.
Okay, great. And to that last point, I'd be interested in both of your thoughts on how the understanding of materiality may evolve through case law. Just for the folks on the webinar who are not attorneys, what considerations should companies be aware of?
So I think this is an interesting question in the U.S. context because there isn't a lot going on that's going to lead to the evolution of new case law. There is a shareholder derivative suit that's pending related to ExxonMobil's use of internal carbon pricing and whether they appropriately disclosed risks around stranded assets. But there are not yet a lot of cases about climate disclosure. I think the more interesting question will be whether the SEC starts to get more active in issuing guidance or commenting on disclosures that people are making or providing comments and responding to requests to exclude shareholder proposals, because those are all ways that the SEC can start to express some views about whether the amount of climate disclosure that's happening now is appropriate or whether they think that more is needed. Historically, the SEC has not been very active on that front. They issued a bunch of comments on 10Ks in the first couple of years after that 2010 guidance came out, but that's been a pretty quiet space for quite a while.
Yeah, no,
Great, thank you.
Hey Fatima, I would just follow on that real briefly by basically affirming what you're saying on the SEC side of things. So most everybody should know that in 2016, the SEC did take comments on this issue as part of a larger request for input from the public sector, and so to the extent that the SEC starts to be more proactive, that's something to pay attention to. But then I'd correlate that to the fact that most G20 countries, in terms of financial disclosure frameworks that they have overseas, are also moving forward and to varying degrees of proactivity in terms of defining and clarifying these issues in the context of materiality, such that companies need to be aware of the potential for different levels of standards in the context of climate risk as to what they should deem material for one particular country may not be what they might want to deem material in the United States.
Thank you. Yeah, and that kind of gets to the last question. Let me ask that to you, Cameron. For multinational companies with assets in different jurisdictions, could you talk about some of the considerations they should be aware of with respect to corporate climate reporting and scenario analysis?
Considerations. I would consider a approach such that, like, throughout wherever they're located geographically, or wherever their business interests are and business activities are occurring, they should really conduct like a roadmap or a diligence exercise to assess what frameworks are being employed, whether the TCFDs are intending to be adopted en masse, and whether standards and metrics and targets are being pursued in a particular country that will ultimately affect business activities, affects asset level interests, or affects supply chain management issues, obviously. And so that's more of a screening and transparency exercise. But I also would encourage folks to particularly pay attention to the multilateral activities, things through the UNFCCC process, things like carbon accounting reporting, things like the efforts to integrate or network activities on the private sector side of things through the Paris Agreement that may or may not have clarifying impact in terms of risk assessment and risk transparency, because of the utilization of some form of harmonized carbon accounting regime. And then ultimately, if the split on a sector by sector basis comes to a point that may align with enhanced data acquisition and enhanced data management in this context, as Maggie was saying, we're not exactly at a mature level for a lot of the physical risks. I would pay particular attention to what the multilateral development banks may or may not be doing on things like coming up with taxonomies for physical risks. I know that I believe the EBRD in Europe has embarked upon trying to diagnose and create some sort of template on physical risk taxonomies that companies within those regions can employ and should be employing. So it's things like that need to be assessed and integrated into what ultimately becomes a forward-looking assessment, whether you're U.S.-centric or U.S. domiciled.
Okay, great. Thank you. So now let's go ahead and turn to audience questions. We have several of those coming in. So the first question, could you speak a little bit more? I think both of you mentioned this IHS market report that references it includes some analysis suggesting that the task force recommendations are sort of doing a misuse of scenario analysis. Could you talk a little bit more about that to explain to folks who may not have read that analysis? Maybe Maggie, you can start, if that would work.
So At core, much of the IHS objection relates to the application of scenario analysis in the securities disclosure context. So I don't read it, and Cameron, if you disagree, I'm very interested to hear it, as saying that scenario analysis is not a useful tool. It is more suggesting that the kinds of questions you're asking in scenario analysis and the variabilities associated with it start to get very far from the types of risks that we have traditionally considered to be material, and so that it's not necessarily something that has a home within financial disclosures at the regulatory level.
Yeah, no, I would agree with that assessment at present, that as scenarios analysis is currently contemplated, right? And there is provision under Regulation SK for calculating and addressing, or at least accounting for, contingent liabilities a company may have. However, this is where the radical departure aspect of the IHS report is salient, is that it really is incongruent with what the TCFDs are recommending in terms of the 2-degree scenario analysis. And on that basis, particularly as Maggie says, that once you get out to the time horizons that we're talking about, the materiality aspect of this is de minimis from a legal perspective at a certain point of nexus with what a company is currently doing. However, the going forward, I think that there's a lot of potential activity in terms of FASB and IASB accounting for contingent liabilities that may or may not have some utility in terms of integrating some form of forward-looking assessments of the performance of a company in terms of contingent liabilities, and so there are similar historical precedents for this, particularly activities that go back to how companies were accounting for the oil crisis of the late 1970s, for example, about how they were addressing the potential for another oil crisis, right? And so those types of things do provide some basis to say that there may be something there, but as Maggie puts it right now, at present, it really doesn't have a home in terms of the existing framework.
Thank you both. And actually, I wanted to introduce my colleague, Nancy Meyer, who wanted to say a few words on the IHS market report.
Thanks, Fatima, and to everyone on the line right now. I am the Director of Corporate Engagement here at C2AS, but prior to that, I worked at IHS Markit and actually contributed to that report. So I think I can also provide a little additional insight into all of the very valid remarks that Maggie and Cameron were able to say regarding the potential misuse of scenario analysis. I believe that in the terms of that report, one of the concerns had to do with using information that could be potentially misconstrued as a forecast rather than as a scenario analysis where you're looking at a lot of different scenarios. I think Cameron alluded to this in some of his comments, that there are a lot of different scenarios that look at a 2-degree outlook and come up with a lot of different ways to get there. So a company could potentially, for example, choose a forecast that actually looks really good or does well for their particular market, rather than looking across a range of scenario analysis. And I think that that's the concern, or was one of the major concerns that report was highlighting around the potential use of scenarios. So I just wanted to add that since I'm sitting here with Fatima. Thanks, Fatima. I'll turn it back to you.
Okay, thanks, Nancy. And then sort of focusing on that, we had a question from the audience about what is the role of the CFO in this space? And I don't know, Cameron, if you could talk about that a little bit in terms of some of the accounting standards boards work that's happening internationally.
Yeah, no, I think it's there's no monolithic answer to this, but for companies that I've worked with, the CFO plays both a quarterback role as well as like a kind of a large kind of managerial input as to the scope and the direction of both the assessment side of things as well as preparation of the disclosure reports, whether they be voluntary or just compliance annual filings themselves. It really comes down to what type of company, what level of engagement the C-suite has, and then the involvement of the CFO is critical in terms of connecting the dots between the financial accounting aspects of this and obviously the data management on things like physical risk or transition risk and those types of activities that are increasingly under the purview of the CFOs, or at least the CFO in consultation with the investor relations folks or the sustainability team, or whatever it might be.
Great, thank you. And then, one thing that, the IHS Markit report referenced was some concerns about confidential business information. So, Maggie, maybe if you could help us understand, how could companies help meet their disclosure obligations while at the same time avoid disclosing confidential business information?
Well, I think this really goes to the strategy prong, right? So if you start to think about how you put together a scenario analysis and what your strategies might look like, there's a lot of really interesting questions there about what are your reserves, at what price can you produce them? This is in the oil and gas context, obviously. How do you think about internal pricing and forecasting models? So there's a lot of things about sort of marginal financial decisions that companies are making and levels at which they are going to be profitable that are implicated by scenario analysis, right? Because at the sort of highest level, the kinds of scenario analyses we see companies doing now are doing things like saying, well, gee, if you looked at all of your existing oil and gas reserves and you tacked on a $20 per ton price of carbon, would it still be profitable to produce them? And I think there are ways of presenting the results of a scenario analysis that do not implicate CBI in a really big way. And I think that's one of the reasons that you see a lot of very broad brush, high level kinds of disclosures now, that you see companies writing these investor reports that say, look, we did the scenario analysis, we looked at $20 a ton, we looked at $40 a ton, we looked at business as usual, and we think in all of those cases, our reserves are pretty robust to carbon pricing and we're still going to be able to produce them, so we don't see a big financial risk, because they're trying to not disclose a lot of CBI. And I think that right now that's a totally fine way to proceed. I think the question becomes, if the trends in disclosure and demand for scenario analysis start to require more robustness and more disclosure of sort of what are the nuts and bolts and the pieces of the data that you put into that scenario analysis and what kinds of assumptions did you make, then it's going to become very sticky very quickly.
Okay, thank you. And let me actually just ask you a follow-up question there. Do you think that companies should disclose why they chose particular scenarios to do their analysis?
I think that's a really interesting question. I have yet to see, and perhaps Cameron has seen some different things, but in the U.S. context, I've yet to see folks depart too far from the IEA 450 scenario in the energy space. So people sort of are saying, this is the scenario we're using, and we're using it because it's readily available, and nobody really has the internal resources to go out and build their own scenarios. I think that if we get to a point in time where companies are departing from taking these sort of more off-the-shelf scenarios for demand or pricing and are going to go make their own assumptions, that they probably will need to explain to the investor community at large why it is that they're making those choices, because there are lots of levers that you could pull in a more fulsome scenario analysis to make things look better or worse for you. And in the absence of some sort of a standardized format, that information is not particularly useful because it's hard to assess what the risks actually are.
Okay, great. Now a question for Cameron. Do you think there should be a different standard for materiality for industries that are already facing greenhouse gas emission regulations, for example, the auto industry? So this is a question from the audience.
Oh, okay. Yeah, I'm sorry. Do I think that no, I don't, and I'll explain why. So I think that what Maggie put up, maybe it was one of her first slides, was the existing guidance that we already have includes triggers on GHG regulation. Okay, and so obviously there might be some utility in clarifying the connection between GHG regulation, for example, just starting with the most basic kind of regulation, which would be reporting, and then going down to things like mandates and controls on GHG emissions. There might be some utility or to have the SEC provide some additional guidance on what the connection is between those regulations and materiality for corporate risks. Sure. But as a threshold matter, those things should already be deemed material to the extent that they impact the business's management and operations. And so going forward, I think that what we're going to see is like a convergence between internal corporate risk management and governance and clarity on such things. And it depends, obviously, on what type of climate regulation and legislation we're talking about. But things like Maggie was saying earlier in terms of companies that have already integrated some form of internal carbon price, or at least they have some sort of carbon neutrality goal, those types of activities, when transposed on top of GHG regulation, really goes to the heart of both strategy, governance, and risk management. And so the materiality as to those issues should be consistent. And I think that's the point to make, is that the materiality in that context needs to be is consistent, at least on a sector basis. Now, whether that means highlighting and clarification as to what materiality means, sure, additional guidance and clarification is always useful, but should it be different? Maybe I'm not answering the question correctly, but I think that to me it should be more consistent than different, if that makes any sense.
Yeah, no, I think that makes a lot of sense. I don't know, Maggie, if you had anything to add to that.
I don't think so. I think that's right. That consistency of information, or of the types of information we're expecting from folks, is really important to making any of this information useful.
Okay, great. There's a question from the audience about the trends that are happening at the state level. And do you see any discussion happening on the state level, whether it's legislative or coming from the Attorney General, trends that would, require more climate disclosure, or even more broadly focused on ESG requirements? I'd just be interested in your thoughts on that.
So I think that one of the more interesting things that's happening, it's an action of the states, I don't know that state level is the right way to characterize it, is that some of the most aggressive entities in terms of using the investor engagement and shareholder proposal process to force additional climate disclosure are state funds. So they are state pension funds, CalPERS, CalSTRS, New York Employee Fund. There's a bunch of these funds that are state-owned assets that states are using to push for additional climate disclosure. If you have CalPERS or CalSTRS in your stock and you have an ESG proposal, you can be certain that they are going to vote in favor of it. So that's something that's happening sort of outside of the regulatory process, but where states are using their heft to try to push the discussion forward on climate disclosures.
Yeah, the only thing I would, I'm sorry, Fatima. The only thing I would add is as Maggie knows, and she mentioned earlier, is the subnational activity that was engaged through New York under the Martin Act is really kind of driving things from a financial disclosure aspect in terms of disclosure of stranded asset risk. And so New York is obviously unique in many regards, but I think that those types of issues, in addition to what Maggie was saying in terms of top-down state funds and state state drives in terms of disclosure on the ESG side of things, and climate risk is important. And then I would actually like to ask Maggie a question about fiduciary duty obligations at the state level, and whether that might be seeing additional activity.
You know, Cameron, that's a really good question. I don't have a lot of visibility into much that's gone on yet with the question of the role of corporate fiduciaries with respect to management of climate risk. It is an area that I think is really interesting and important to watch, but I think, again, for me, it goes back to that tension of, you know, what are the corporate fiduciaries managing for in terms of time horizon, and how does climate risk play into that? But I'm not aware of particular kinds of guidance or other rules that have come out that are specific to climate change at this point in time. If you are, I'd be fascinated to hear about them.
Go ahead, Fatima. I'm sorry. Please.
Oh, I was just for the folks on the webinar who are not aware of the issue that Maggie and Cameron are discussing, there is a uniform law governing investments by trustees, and each state has its own, you know, variation on that. But the idea is that there is a responsibility of fiduciary management, of prudent management of institutional funds, and the question is, what does climate risk mean in that context? So how could a fiduciary prudently manage institutional funds while being aware of climate risks? And there may be an opportunity there for activism. So we'll watch that space. But feel free, Cameron, to add more.
No, you covered it well. That's where I was going. So that's perfect.
Great. And then I have a question for Maggie. You mentioned in your presentation that some of the proposals that passed were related to 2-degree scenario analysis, and I was wondering if you had any more information on how many of the other climate proposals passed?
That was a misspeak by me if I said some of. The proposals that passed last year were all 2C proposals. There were a handful of other climate risk disclosure or climate in supply chain kinds of proposals that were out there, but the proposals that passed last year were all iterations of the 2C proposal.
Great, thanks. And then I had a question for both of you, which is, you know, as you're advising clients on climate reporting, on scenario analysis, do you have recommendations for good legal resources that companies should use as they begin this process of making sure all the different departments are working together? Are there sources of information that could be helpful?
Yeah, I think actually there's quite a bit in that regard. So rather than just selecting one or two, I think what at least I can endeavor to do is get Fatima like a kind of reference sheet in terms of identifying best practices, some legal references that might be useful in terms of identifying the existing integration of things like the TCFDs abroad, some of the activities that other countries are doing that might be different than the U.S. So I think what I'll do, Fatima, after this is I'll put together a reference sheet that you can circulate for some of the issues that might be useful to folks to review.
Thank you. Yeah, that would be really helpful. We definitely want to be a resource to companies as they continue on this process of looking at the task force's recommendations and deciding which aspects they're able to implement and how to do so. So with that, I think we've talked a lot about the U.S. trends and the global trends, and maybe I'll just hand it to each of you to provide any closing comments if you have any, and maybe I can turn to Maggie to start.
So I think I will close by reiterating something that we've talked about a lot here, which is that the legal standards around climate disclosure at the moment really murky. I do think that everything Cameron said is really important, that this is really being led by activities abroad as opposed to what we're seeing in the U.S. But we are seeing a lot of investor sentiment that is really going to demand increased disclosure. And I don't feel, with respect to scenario analysis, that many companies are prepared to go in and do a scenario analysis starting from scratch and get it all done in 1 year. And so my closing advice to people would be, if you're contemplating scenario analysis, even if you think it's a 2, 3, 4, 5 years out project, it's probably time to start grappling with it and thinking about what kind of an analysis do you want to do, and do you want to use off-the-shelf things, or are you going to build your own, and what kinds of data would you need, and how would you go about getting it and making sure it's of sufficient quality? Because there's a lot of really tricky questions there that I think require more thought than, oh my gosh, an investor just called and said they want this from us and we need to figure out how to get it done between October and April.
Yeah, I think that's excellent place to start for where I would conclude my remarks. Fatima, would be, I think that climate risk disclosure for a lot of companies is unidirectional. It's something that they're either responding to investor demands, or alternately they're endeavoring to do this for some form of transparency or assessment of forward risk. But I would encourage folks to, as Maggie put it, even if you think it's five even more years out in terms of some form of additional stringency or clarity at the U.S. level in terms of disclosure from a compliance perspective, I would encourage folks to answer that for themselves two questions. The first one is what do my investors or my potential investors need to receive in this in terms of data and information as to what my company is doing, how my company is performing in the context of climate risk, and that includes all of the physical, the regulatory, the transition risk issues. That's a harder answer to answer than it is to ask. But the second one is that how does climate risk in terms of once we have some form of fulsome regime, a little additional clarity on materiality, how does this effort, or how does reporting in terms of acquisition of data and reporting of performance, how does that redound to and consistent with the company's operations and management going forward, such that it becomes more of a strategic tool rather than something that is separate from the enterprise risk management activities that the board is determining, or alternately the C-suite is looking at. How does this integrate with going forward business endeavors, business investments, business strategies? Obviously, a lot of proactive companies are already going that way, but I would encourage even the folks that are not exactly at a robust level of disclosure start to think in those terms for a host of reasons. How does this effort, or how does this new climate risk disclosure approach to things, how does this integrate into my strategic growth strategy, and going from there?
Okay, thank you. Thank you for those closing comments. I think that's a really good place to end today's conversation. And I want to thank our panelists again for sharing their expertise in this emerging area. It's pretty exciting, and certainly we want to make sure to keep the conversation going. So we will follow up with more programs on this topic. So thanks, everyone, and I hope you enjoy the rest of your day. Thank you.